Mr. Chapman, you closed your statement by talking about Congress creating a definition of undue hardship. Something has to give here. Whatever the definition under the Bruner test is today, it practically is no relief. I mean, when you look at the other areas of non-dischargeability under the bankruptcy code, whether it's alimony or child support or taxes, that sort of thing, there is no undue hardship escape. I think Congress believed it was creating some sort of an out for the hardship case, but in the application of the Bruner test, that just doesn't work. Do you have a definition that you have created? You made a reference to some elements.
We have not created a specific definition, but it's a combination of the temporal discharge period as well as the definition of undue hardship. I think both should be addressed, albeit with the reinstatement of a temporal discharge, the undue hardship definition becomes, I guess, less impactful, but still important.
So I have tried, with no success, to appeal to the Department of Education, which is the bill collector in name, to establish some sort of reasonable standard. I use the example of the quadriplegic disabled veteran, who's in a terrible state and is never going to see a change in circumstances and needs a helping hand. It doesn't seem to touch them in any way. I believe they are contracting out some of these collection services, and perhaps there may be some perverse financial incentives to always say no. But in 5,000 cases since 2012, or 5,000 clients since 2012, you've had 5 cases only at PLC. It gives you an indication, 1 out of 1,000, that you think may even have a chance under undue hardship. Is that correct?
Just to clarify, it's 5,000 consultations, so sometimes people come in for more than one consultation, but yeah, the number is very low.
Well, and I also want to address the issue, and I think rightly so, the ranking member raised the issue of moral hazard in terms of whether or not we're going to make it just too easy to file bankruptcy and people will be taking advantage of that opportunity. You seem to make the argument, you do make the argument, that this is a tough thing to sell to a lot of people, even though they desperately need bankruptcy. It's their only escape from their current situation. And that strikes me as an honest appraisal of what most human reaction is to the fact of going through bankruptcy. People aren't happy to do it or anxious to do it in most cases, and that's been your experience.
Absolutely.
Attorney General Raoul, you've seen these schools, for-profit schools in particular, and Ms. Barta was a victim of one of them, Ashford. These schools are notorious. 8% of high school students go to for-profit colleges and universities. Over 30% of student loan defaults are from students in for-profit colleges and universities. They get into the system, they borrow too darn much money, they either then drop out or then get a worthless degree and can't pay it back, and it just keeps building in interest. You've tried to appeal on behalf of some of these classes of students with some success, I'm happy to report, but there are many of them that don't get that kind of relief or protection from the deception that they've been witnessing.
That's right, Mr. Chairman, and there's consensus among state attorneys generals. As I mentioned on some of these actions, there is a bipartisan effort to hold these bad actors accountable. And even with the limited success, there are many students who are just left without relief.
I'm going to defer to my colleagues as they've been waiting patiently here, but I think I hope we are moving toward a consensus, and certainly Senator Corner and I invite others to join us in this conversation. We have talked about this student debt for how long? Decades, and we haven't done a darn thing about it in a long time. We can do something now that is reasonable and meaningful, and I think restoring the 10 years is a reasonable step in that direction. As well as accountability for the schools that are abusing the student loans from their point of view. It's been a long time since I've been a practicing lawyer, but I think about a 19 or 20-year-old young man or woman facing the prospect of $10, $20, $30, $40,000 in debt and signing on the bottom line at that point in their lives. They need some help. They need some advice. Going back to the point made by Senator Grassley, somebody's got to say to him, wait a minute. You don't need to borrow all that money, or there's another way to do this, or perhaps you ought to reassess the whole situation. They don't have that kind of counseling. It's a university selling student loans from the government, and students, many of them with no life experience to turn to and no reliable parents may never have been to college themselves. That puts us in this predicament many times. So I think we're moving the conversation in the right direction, and I thank the panel for being here.